Good afternoon, and welcome to Georgetown Law's discussion on Trump, his taxes, and the power of Congress. We're looking forward to having a great conversation here. We'll talk for about 30 minutes and then look forward to taking your questions and doing our best to answer them. So please begin submitting those through Georgetown Law's Facebook page. I'm Josh Geltzer. I serve as the executive director at Georgetown Law's Institute for Constitutional Advocacy and Protection, and have the pleasure of teaching a number of courses that relate to some of the separation of powers issues we'll be talking about in this discussion. And I am delighted to get to do this with my wonderful colleague, Vic Nourse. Let me allow her to introduce herself. Vic.
Hi, Josh. It's great to see you, even if virtually. I'm delighted to be here. I call you the real lawyer here because you actually litigate. I teach about Congress. I teach about the separation of powers, and I've been writing about that since about 1995. I've also had the ability to both serve as a lawyer in Congress as well as in the White House. So I bring a little bit of practical experience in that dimension to the conversation, and it's going to be fun to talk about this great case.
It's going to be great fun. And again, we want to involve those of you watching, so please do begin and throughout this conversation, continue submitting your questions on Georgetown Law's Facebook page. But let's set the scene. Thursday was a big day at the Supreme Court, and it was a big day for President Donald Trump in a number of cases about his financial records. Let's start by talking about how these cases came to be in the first place. And maybe I'll ask Vic if you'll talk about one set of those cases, the cases that started with congressional subpoenas. How did we get here?
Okay, well, long before impeachment, the Congress and two separate committees were looking into issues involving money laundering as well as foreign interference in our financial system as well as in elections. And these committees subpoenaed Donald Trump's accountants and Deutsche Bank, and they wanted to get records from these third parties who are private people. As they traditionally do. It's a common thing for Congress who wants to investigate, say, oh, how do people finance terrorism or how do they launder money, to ask banks and accountants for this kind of information. And in fact, the banks and accountants agreed. They agreed to provide the information, and then Donald Trump sued them to stop them from providing his information. And that battle, his suit to enjoin this subpoena, led to the case that I'm going to call Mazars, which is his accounting firm.
That's great. So that's the congressional subpoena set of cases, which we'll call Mazars for purposes of this discussion. In addition, we had decided on Thursday cases about subpoenas for Trump's financial records, a subpoena issued by a New York State prosecutor, by Cy Vance, the district attorney in New York, after reports began to circulate of, we'll call them hush money payments. Cy Vance, being a prosecutor, launched an investigation, and as part of that investigation, wanted the financial records that might indicate whether these hush money payments were as they were described in some reports, and in particular, whether they broke the law. So Vance's office issued a subpoena, and Trump, somewhat similarly to the path you described, Vic, went into federal court and sued, saying, I don't need to, my records should not be turned over to this state prosecutor. I'm shielded from this sort of inquiry by a state prosecutor. And that case, having made its way through the lower courts, went to the Supreme Court and was also decided on Thursday. So I'll be referring to that one. We'll be referring to that one as the Vance case. Now, let me offer a big picture description of what happened Thursday, and then Vic, you react to it and tell me if you see it the same way. The biggest thing I think that happened Thursday in both of these cases, or really these two sets of cases, was that the Supreme Court said no to Donald Trump's vision of what it means to be president, and in particular, how that shields someone from scrutiny. The court said, no, you don't get a total wall put up around you. You don't get to say, in all cases, for all reasons, no to your bank, your accounting firm, to having your records turned over to a state prosecutor like Vance, or even turned over to congressional committees that might be investigating you. There are more details, but that's my big picture takeaway. Vic, how would you describe the big picture on Thursday?
I think that's right. In my view, the Trump lawyers were trying to make arguments that were really quite inconsistent with precedent. So in the Nixon case in 1974, they basically said the president doesn't have absolute immunity, particularly in a case like Vance, where it's a criminal proceeding. Every person's evidence, including the president's, is needed in a criminal trial. And they reaffirmed Nixon in that sense, even though Trump's lawyers were basically trying to say, no, that's not what it held. So they were making a pretty aggressive argument. And I agree with you entirely. In both cases, the aggressive Trump vision of the presidency was firmly rejected, even by justices like Justice Roberts and others on the more conservative side would say that would be much more likely to embrace a pro-president view, were unwilling to accept Trump's view. So that is the good news. Precedent was upheld, and both of the opinions are relatively moderate, in my opinion.
Now let's maybe break out the two cases a little bit more, go into a little more depth. I'll start with the Vance case. The way I see it, Cy Vance, the state prosecutor, had as good a day at the court as he could possibly have. Now, the reason I say it that way is he does have more work to do. It's not that his grand jury immediately gets these financial records that relate to Donald Trump. The Chief Justice, in his majority opinion for the Supreme Court, said there are other sorts of more specific, more narrow resistance defenses that the Trump lawyers can go back and raise in the lower courts. But that's no different from what the court below, which had ruled against Trump, had already said. In other words, this was as good as it got for Cy Vance, because the only issue going up, this very bold, I think very extreme argument that was being advanced by Trump and his lawyers, that was rejected. What about in the congressional subpoena cases, Vic? Is the answer a bit more complicated there?
Yeah, the answer is a bit more complicated. And for those of us who study Congress, we thought that the precedent was pretty clear that for all citizens, whether it's you or me, if Congress says there's some legislative reason that they need our records, we have to comply. Chase has to comply, Mazars, banks, they do this all the time. Apple, Enron. Countrywide mortgage when there was the Great Recession. So companies are used to these kind of things. And those of us who study Congress have known that there's about 20 Supreme Court cases since 1920. So over 100 years, it's been a pretty stable standard. And the big difference for us Congress nerds is that here they created a new rule for the president. Okay, usually you just have to comply if Congress can come up with a legislative purpose, and the view of legislative purpose is very broad. If it's plausible that you're going after money laundering, you can get the bank records. That's the very deferential to Congress view that you get in all these other cases. That was the baseline. So this is new, and that's why it's different than I think the Vance case. Vance follows, in my view, you may differ, but from Nixon. Because that too, the Nixon case involving the tapes was a criminal proceeding. And the request was for the president's evidence like any other citizen. In Mazars, in the Congress case, they basically create a new rule for the president. So citizens have to do it under any circumstances, but there's a 4-part test now that Justice Roberts enunciates in his opinion for the majority. And now the Congress's lawyers have to go back to court and try to meet that test. There were a couple of dissents saying, where'd you get the test? Because there's not a lot of precedent out there, but this is unusual. The court admitted this is a strange case. Never before has Congress actually gone after the president's personal records, as opposed to going after attorneys general, which they've done, as opposed to going after other government officials or private companies. They've never gone after the president, and the president has a unique place in our Constitution. That's true. And so they created this test essentially to avoid harassment, to force Congress to come up with a closer fit between the actual legislation, the request for documents, and their need for the documents. So if I were their lawyers, I would go back and say, look, we are investigating money laundering. We are investigating foreign influence in the election. We know that from the Mueller report. That is a legitimate legislative purpose, and that could involve the president of the United States, given the evidence in the Mueller report. So therefore, here are the specific records we need. So as long as they get more specific, I think they might prevail. The problem is timing. And so I want to know from you what you think as a lawyer about the timing of both the Vance and the Mazars case. Will they be decided before the election? Can they be decided before the election?
It's a great question. In fact, it is the first question we have come in from a viewer. It was a question all about timing, which is a good opportunity to remind those watching that they should keep sending in their questions as we talk. So maybe it's worth establishing the baseline here. And I worry perhaps that some of us who talked about these cases didn't create the right baseline for those following them. There was no world in which late in the day Thursday, the financial records were going to be made public. That is not how the Supreme Court worked. That is not the posture that this litigation really was in. Indeed, these are requests in the first case, the Vance case, for a grand jury to obtain the records. Grand jury secrecy would still apply to that grand jury's work. In the other case, the House of Representatives would obtain the records. All of this might be on a pathway towards making them public eventually. And I start from a place where, as a member of the public, I do want to know about Donald Trump's finances the way I want to know about it for the many other presidential candidates, or in Trump's case, actual president, who in the modern era have, on a voluntary basis, made that public. But there was no world in which Thursday, suddenly by late afternoon, those financial records were going to be posted on some website somewhere. But I do think that the Vance case can, and maybe feel even more strongly that it should, move quickly from this point forward. Because to my mind, the Supreme Court, the nation's highest court, has answered the really big question. In some ways, the really fun question for those of us who like constitutional law, but the really big question, this threshold question of, is there something in Article 2 of the Constitution or elsewhere that says hands off to a state prosecutor, state investigator, and means that you can never get at this stuff? And once the Supreme Court answered that resoundingly and clearly no on Thursday, there are little questions left. The Chief Justice said those questions could be the sort of subpoena-specific questions that, in fact, one of us might raise. Is this overly burdensome? Is this broader than it needs to be given the stated purpose for it? And those are the types of things that, to my mind, we as the American public should expect our federal judges to move quickly, to get briefing on quickly, to rule on quickly. And if the Supreme Court is going to play its traditional role, the court should feel comfortable not addressing and seeing as the littler questions left to lower courts to decide in shadow of the Supreme Court's big picture pronouncement on Thursday. That's a mix between a prediction and a hope, but I think it's a reasonable expectation given the importance of all this and given the fact that the prosecutors and investigators of New York have been waiting a long time for this since they began these investigations. Vic, back to you on the congressional side, maybe two questions. One, you're as much an expert in this four-part test as anyone else, given that it's brand new. How do you think the House will fare, or maybe even some of the different committees of the House will fare back in the lower courts trying to meet this newly articulated test? And what's the speed at which you think that litigation could move?
Well, I tweeted this out yesterday. I think that they should narrow their requests. I mean, Justice Alito in dissent said they haven't satisfied the standard. They're used to issuing very broad requests because that's their standard MO, right? They didn't do anything wrong with the rules that existed at the time, but the court just changed the rules on them with respect to the president because it had never been decided. Now, when we've seen this, I've often heard that Congress doesn't do anything, but we've had the CARES Act. When Congress really wants to do things, I mean, I've seen in the first Gulf War, the generals come down and have a resolution and, on the same day. They can act very quickly. If I were the House, I'd get a new resolution. I'd pass a resolution with a much more specific document request. It was pretty easily drafted. I would have the leadership bring the committees together, basically, to serve and just illuminate the multiple purposes and have the whole House vote for it quickly, go back into court with the narrowed request. It's going to take much more briefing because it's a new standard. It's similar to what actually applies. I mean, it's sort of common sense that you don't want burdensome, harassing litigation. Judges are familiar with that. But there's also one part of this test that could pose a problem because it could raise new constitutional arguments. There's a throwaway line where the justices cast some doubt on the ability of Congress to actually legislate with respect to the office of the presidency. Now, I, for one, never had that doubt because of having worked in the White House. It's a highly regulated place in terms of ethics and in terms of confidential.
Presidential Records Act, you must maintain your records.
You can't even pick up the phone and call lots of people lest you create a federal advisory committee. Lots of regulation. And a lot of it has to do with to avoid conflicts of interest and things like that. So there's a lot of that legislation. I doubt seriously that the court will actually hold it unconstitutional, but they held that branch out to the lawyers. So there's going to be argument about that. And I think that's the way that Trump's lawyers will recycle some of their more aggressive arguments that they lost on. They'll just put it into this bucket where they say there is a constitutional question about whether Congress can actually regulate the office of the presidency. Now, I don't think that's going to win at the end of the day. If that's true, then there's a whole bunch of legislation that is suddenly unconstitutional. And if Congress has the power to push back on that, it just defunds the office of the presidency. It just no longer pays anybody's salary. One of our colleagues, Josh Chaffetz, just had an op-ed in the New York Times suggesting there may be other ways that Congress can seek to enforce the release of information. They're pretty much hardball, congressional hardball. And I don't know whether they'd be, it seems doubtful to me that the Senate would go along with them. But, I think Congress is not going to like this decision, to tell you the truth. But that's all the more reason for them to fight it. And it's all the more reason for them to act quickly to fight it. My worry is just I think the judicial time spent in applying the test will take much longer than the Vance case. Because the Vance case is using old conventional standards. We have a new standard. We have more constitutional arguments that are being invited. And so I think the Mazars case, the Congress case, will take longer.
And let's stay on this question of timing and next steps, because we're getting some more questions from viewers on exactly that, which again is a good reminder for me to encourage continued questions to come in. But what happens in the Vance case? Let's assume that the optimistic end of my prediction proves right, and that in fact lower courts resolve lingering or remaining challenges to the subpoena issued by Vance relatively quickly, and that Vance obtains financial records that finish perhaps making a case that he's prepared to make of some criminal activity. How quickly could he move to bring charges based on that? Well, my answer is quite quickly. And along with another colleague of ours, Vic, Neil Katyal, I had a piece with Neil that appeared in the Washington Post yesterday that shows how quickly indictments can move once the key information has been obtained by government. So if you look at time of break-in to initial indictment in Watergate, if you look at when Customs obtained key information with respect to Iran-Contra from that moment to the moment of initial charges, we can talk weeks, days or weeks, rather than months or certainly years when key information. And again, that means there has to be something there, right? The goal in obtaining these financial records isn't just to have them, it's to scrutinize them and see whether they indicate criminal activity. But if that's there, and if the Vance team finds that that's there, the time between that and criminal charges, and I realize this is a dramatic thing to be talking about, criminal charges brought by a state prosecutor conceivably against the sitting president of the United States or potentially those in his orbit. But even that presumably would have some effect on how the electorate thinks about that sitting president as he seeks re-election. That could, at least, I'm emphasizing could, move pretty quickly. The congressional side of things, as you point out, Vic, seems at a minimum to be destined to move more slowly, if only because there are arguments to be made and litigated applying the very test that the Supreme Court just articulated on Thursday, which then leads me to a question to send back to you, which is maybe zooming out slightly here. As Congress in future years, future decades, deals with the ramifications of this opinion for just general oversight of presidents, interactions with presidents and their legal teams. How much do you think this affects the, I'll call it balance of power in some ways, between a Congress and an executive branch that often don't end up in the US Supreme Court figuring out, quote, who won or who lost on a particular legal argument, but instead have what's called an accommodations process. Sometimes it's a little bit more of a fight than an accommodation, but ultimately in the shadow of where the court might land, work out whether certain documents get provided or not. How does this play out in over a longer term, Vic?
Well, the question is how broadly you read the opinion. I mean, I read it as limited to documents, whether pre-presidency or even current presidency, that's focused on the president himself, right? So there are lots of cases where, and going back to 1920, you know, it's an attorney general or an attorney general's brother, or, you know, General Grant's whiskey ring and somebody. We've been having these investigations for a long time with lots of different presidents and people around the presidents. But those investigations were not targeted at the president himself. So I read it pretty narrowly. So the prior practice, which happens every day, literally every day in Washington, some congressional committee rings up the White House and says, I want X document. And the White House could say no. And then Congress has to go to court. But most times, there's just a process of accommodation, and there are different standards. So some administrations, the George W. Bush administration, was very eager to assert executive privilege, for example. The Obama administration was not eager to assert executive privilege. They just followed a different norm, but it was all, the norm followed the general process of accommodation. I don't see that changing dramatically. I do think Congress, and one thing we need to realize is there's a whole nother suit about the tax returns. There's a statute that was enacted, a tax statute that was enacted after Nixon turned out to have defrauded the taxpayers. And it requires that the IRS give the tax returns to a House committee confidentially, right? So that they can review whether the president is cheating on his, it's only been him, his taxes. So that case is still in the somewhere in the DC circuit, I think. Yeah. So this isn't ended. These cases are going to keep going on. I think the fastest action will happen in New York. But you're going to see that other case. That case is about how you read the statute. I think they're making a very aggressive argument. I do a lot of work on statutory interpretation. I think it says shall. There's really not a way out of that. So I don't know how, you know, they might be pushing, Congress might push that. But the other thing is, should there be united government? And this is only going to happen if the House, the Senate, and the president are in the same party. They might want to think about passing legislation that would help resolve the clogging of some of these cases, because when they do go to court, they get stuck and then they're never resolved. So Harriet Miers went to court, then the president was unelected. So these cases don't come to a lot of resolution. And one of the things I've asked for since last year, I wrote an op-ed about this, which is we need a timeline. We need like a 30-day, 60-day timeline for the courts to resolve them. Because otherwise people can manipulate the system and delay so that it's never decided. And when the rules are really unclear, that's the worst situation because you can't negotiate around mush. And we have some questions up here. I don't know whether we should be answering questions.
We should be. In fact, I'm going to make you answer one because it's a question of congressional power, and you're certainly the better person to answer that. And I'll give our viewers both a reminder to keep sending questions and a heads up that we'll probably talk for about 15, 20 more minutes for this conversation. So keep the questions coming. But we have an interesting question here. The hypothetical posed is that Vance and his office in New York do obtain the financial records via the subpoena that was not blocked, is probably the fairest description by the Supreme Court on Thursday. Does Congress have any authority to then turn around and say, well, now we have a new target for a subpoena? We have this state prosecutor's office in New York that we know has these documents. Mm-hmm. Could one more of the House committees serve a new subpoena on Vance's office saying, we're pretty interested in what you just got. We'd like to see it too.
Yes.
And what happens then?
They have broad subpoena power. Well, what happens then is that Trump will go to court again to enjoin the production of the documents. So he'll seek to enjoin Vance from giving them to Congress. Because otherwise, you know, obviously you could end run grand jury secrecy and a whole bunch of other things. So he'll have some legit arguments about that. But so we'll be back at square one. The thing is, if they target this very narrowly, if they wrote the request very narrowly, they could actually meet the standard that was just set out. Now, Alito said that the current requests don't in his dissent. I'm not so sure that's right, but they could rewrite it. And if Vance got something very specific, they could rewrite it so specifically, and it would help them rewrite it specifically enough to actually win in court.
And let me ask you, you've mentioned a couple of times that Justice Alito, in dissent in the Mazars case, said that he felt that the various subpoenas issued by the House committees do not meet the four-part test articulated by the court majority. How much stock should we place in that? I remember being, I think, not just a young lawyer, but actually a summer intern once, and citing a dissent in a memo. And a lawyer said to me, "You know what else a dissent is called, Josh? It's called a view that lost." It never supports your point, if the opposite. Now, that's probably too extreme, and I certainly say this with great respect for Justice Alito, and indeed for the court writing these dissents that as law professors we love, because we have arguments on both sides to then grapple with our students. But how much stock should someone place in the fact that a dissenter expressed that view on the issue that's now about to be litigated in a law?
I wouldn't place much weight on it. I mean, I agree. I often say when you look for legislative evidence of the meaning of a statute, people keep citing the people who oppose the bill for the meaning of the bill. That's wrong, right? No, the meaning of the decision is what you have. And it's a moderate decision shared by, written by Justice Roberts. Lots of people who were appointed by Republican presidents are going to find that completely determinative, and Justice Alito's dissent not particularly powerful. On the other hand, if you are inveterately a strong presidential power person, it might be an invitation to another judge to think, and I suspect he wrote it for this reason, for another judge to dissent and feel somewhat comfortable that they weren't going outside the pale. They weren't making something up. I don't think it would be appropriate. Justice Thomas dissented on the grounds that Congress only has the impeachment power. It doesn't have legislative subpoena authority. That would be huge. Because in fact, this is normal operating practice for Congress, and we all benefit from it, because most of the subpoenas they do they're trying to get rid of waste and fraud. They're trying to save people's money, basically. And that's most of what they use the subpoena power for. If that were true, and that was what I was worried about with these cases, because the court there's a certain contempt, I think, that some of the justices have for Congress. And that comes from their horrible confirmation hearings. I mean, I get it. If you've ever been through such a battle, and yes, I was nominated once. It's really—
You're speaking from experience here. Yeah.
It's a negative experience.
That's a very diplomatic, I suspect, description.
It's the best form of government. It's the worst form of government except all the others. The famous Churchill line. So we're stuck with it if you want people to actually vote for their government. So anyway, do we have more questions?
I'm going to encourage questions to keep coming, and let's stay on where we've found ourselves in this conversation, which is to just talk at least a couple more minutes about the dynamics of the court and what this decision may reflect, because we've talked about what it means for the president, what it means for Congress, what it means for state prosecutors and investigators, but let's talk a little bit more about what it means for the court. This decision, or these decisions, I should say, came at the end of a pretty dramatic term, a lot of high consequence, high profile cases, and a term in which at times the chief justices vote surprised some people. And let me try this out on you and see how you react to it, Vic. I in some ways see these cases as in a line with the chief justice's vote in the DACA case to find the termination of DACA by the Trump administration to be unlawful. And indeed with the chief justice's, again, surprise to some, vote a year earlier to find the Trump administration's attempt to add a citizenship question to the census unlawful. And let me tell you in what sense, because in some ways these are very different. Those two I just mentioned are administrative law cases. These were, constitutional law cases. But here's what seems in some ways similar about them. The Chief Justice seems to me to yearn for an executive branch that looks somewhat normal. And there's a lot of wiggle room for what a normal executive branch can look like. A lot of room for differing policies depending on who the president is, different views of the law, different litigation positions even. But what I read those administrative law cases to say, as I take the Chief Justice's opinion in both of those, is this isn't anywhere close to normal. This basically looks like a lie. It looks like a deception. It looks like a fraud by the executive branch. It's conceivable, the Chief Justice seemed to me to say, that an executive branch could add a citizenship question or could at least conceivably terminate DACA, but at least not the way these guys did it, not based on this justification. Here, again, it's a president who's out of step with normal. There is an interesting realm of debate as to what a normal president would say can't be touched by congressional subpoenas, can't be obtained by state prosecutors. But this is so far beyond it, this proposition of basically a complete shield from scrutiny that was advanced by this president here, that again, we have the Chief Justice writing two opinions saying no to that. Is that your take on sort of a dynamic of this court, or at least sometimes a 5, sometimes 7 justice majority of this court over the past couple terms?
Yeah, I think that the Chief Justice is deliberately rejecting extreme positions. And even when the political outcome might not be expected. So liberals are shocked about maybe the sexual orientation case or the DACA. And DACA, they actually had to do some gymnastics involving which of the explanations the government provided they're going to look at. Very nerd-like inside baseball stuff about administrative law. And he was willing to do that, even though the position, DACA DAPA is favored by liberals and maybe not by conservatives, to keep the court in a sort of even balance mode, to try to support the statement he continually says there are no Obama justices, there are no Trump justices, that he's a rule of law Republican, let's put it that way. And he cares deeply about that. He has become the court's most powerful member now, and he's showing it. And he's showing it in a way that, although people found this unexpected in terms of results, if you look at the way he's writing the opinions, they're very process oriented, which is the ideal of neutrality to which most moderate lawyers embrace. So even though I'm saying Congress is going to be shocked now by this opinion about the president, it's very lawyerly. I mean, to provide the 4-part test it looks very similar to the kinds of standards you'd have in a court of law, and just applying those to a very, contentious debate between Congress and the president. So even though I say, well, where did he get that from? When Justice Thomas goes ballistic, like, where did you make this thing up? It's lawyerly. It doesn't look like it's the normal kind of thing we teach every day. So I see him as an institutional loyalist. He loves the court. He loves the law. He believes that it is an institution that can temper the political winds, and he's going to try to use it for that end, even if that means coming out with a result that is considered liberal, along a political dimension. But no, this has been definitely the Roberts term.
So I'll ask one more question here, and then unless other questions come in, we can call it a day. But let's say 10 years from now, you're teaching constitutional law, you're teaching separation of powers. How do you think you will teach this case, Vic? Will you teach this as one that had big consequences for how Congress actually operates day to day? Do you think it's one that will affect other jurisprudence in other separation of powers cases that make their way through the courts over the next decade? Do you teach it as one where the court got something roughly right, or at least rebuffed extreme positions by Donald Trump, but basically that was the main consequence of it? How do you think you'll teach it in a decade? I'm assuming that it's worth making it onto the syllabus in a decade. So tell me if you think that's even the right assumption in the first place.
Oh, I think it'll make it on the syllabus, because there are not that many cases that actually are decided by the Supreme Court, have ever been decided over 200 years, in which there's an actual institutional battle that finally makes it up there because typically people resolve it or the case dies before the court can get it. So it will be taught. I don't think, since it's so focused on the president as an individual, I don't think the fact situation is likely to come up, number one. And two, I don't think it's going to have a big effect. The case involving the CFPB this term, that actually is likely to have a bigger effect on how Congress structures institutions when they create the institutions, because Congress creates the executive branch. It funds it, he creates the schema, who's appointed by whom, and then hands it over to the president to actually execute the law. That's going to have a bigger effect, I think, in terms of practice. And here's why. I mean, most people who run for president have been in politics for a while. You don't just start out, although some people do. Recently, we've had a few. But even then, all their records are out there. They tend not to take this position of secrecy. And so the fact situation is pretty unusual. It's also prior behavior. It's not in the office. I mean, that's what really you're working on day to day with FOIA requests from private citizens or from congressional requests. That's what presidents and their lawyers have to deal with on a day-to-day basis. I suppose there could be, if there's a different president and there's something, I wouldn't put it past, people to go, state attorneys general to investigate the next president, who is, if Trump wins, it's Trump, but if not, I wouldn't put it past them. They've been given a green light. So the other parties, attorneys general, et cetera, I don't think there's going to be harassing stuff, but there might be investigations. If there's something there, it might actually be helpful in a weird way, because sometimes we live in this sort of conspiracy theory Twitter universe where things get magnified. And so sometimes allegations which are false, it would be nice to know if a grand jury did investigate X allegation about something, because the court system does rely on fixed principles, and we do tend to trust the rule of law. So it might actually be helpful to dispel some rumors. And I think one of the reasons people have been so worried about President Trump's records is what is in there that we're fighting about. The more he insists, and with the radical arguments he was making, it makes us all nervous that that's just the tip of an iceberg. And so I think bottom line is, I think the Vance case may have a much bigger effect than the Mazars case in real life.
And those comments, I think, answer one of the two questions that just came in. So one question was about applying the logic of yesterday's decision to things like transcripts of Trump's meetings with foreign leaders, to which my sense would be this was really about the personal financial records of the president. There is a body of case law about obtaining all sorts of other records of a president as that president does his, or I hope someday her, official duties, and there can be fights over privilege and classification and all sorts of things. But I see this as really being about the personal records of that person who's president. Is that fair, Vic?
Yes, and the real case that's closest is Clinton versus Jones, because it was something about his past, the president's past, an allegation of sexual harassment. And it was his personal past. It wasn't anything he did officially. So if these are official records, then the president can assert executive privilege, as he did in the impeachment. And then there are various rules that the DC Circuit has made up about, I shouldn't say that, but has created to, negotiate about those kinds of things. And there's also FOIA, which is interesting, but we saw this during the impeachment. It's a statute that allows you, it's a sunshine law, so that private groups can actually litigate. And there are both liberal and conservative groups that do this, and they ask for documents from the State Department or from the Department of Defense. And they actually did release some of those documents that were relevant to the impeachment debate, even when Congress couldn't get its own subpoenas enforced.
So another question that came in as we were talking about the dynamics of the court, namely the fact that you had Justice Gorsuch, Justice Kavanaugh. I think a fair description is voting against the president's position in all the cases we're talking about on Thursday, as well as Justice Gorsuch writing the opinion on the Title VII issue. Feels like a lifetime ago, but I think it was just a week or two ago. And what does that mean for if there's another Trump term, his approach to justices on the he might nominate for the court? And we'll make this the last question. I'll take one stab at this. It may not be a total answer to the question, but I was struck that yesterday, after the decisions came out, the White House press secretary said, well, these terrible decisions going against the president over and over again suggest that we need more conservative justices on the court. I don't know if that means more numerically or more conservative on a spectrum, to which my thought is it may just mean that this president really keeps violating the law, both in an official capacity. So think of the citizenship question case, think of the DACA termination that's running the executive branch in a way that a majority of the Supreme Court is saying is contrary to law. Or in this case, violating the law in the sense of advancing legal positions to shield third-party banks and accounting firms from supplying records to investigators that the Supreme Court is again saying is out of step with the law. So it strikes me that what's out of whack here is not so much the jurists of the Supreme Court, but the legal positions advanced by Donald Trump. That seems like the outlier to me. It's not clear to me what justices you'd find who would necessarily yield different votes in cases like this, where the positions being advanced by Trump strike many of us as so extreme. But what do you think, Vic? What do you think this might mean if indeed Trump does win re-election, how he thinks about filling future court openings?
Well, I mean, I agree with you in general that some of the arguments, particularly the unitary executive bringing this back, I mean, we thought we got rid of that during the Guantanamo case. At least I thought it was gone. I mean, it was a position of George W. Bush with respect to torture, and then the Supreme Court in a series of decisions litigated by our colleague Neil Katyal, rejected that. So I kind of thought that was dead, but the lawyers brought it back. So they are making extreme arguments, in my opinion, in some of these presidential power cases. I also think that lawyers have a certain culture that we aspire to. And, you know, people will probably find it shocking that Justice Gorsuch wrote that sexual orientation decision. But you know what? If he had taken the position of the dissenters, people could have argued that sexual harassment law was all illegal. There were many cases he would have had to overturn. So that lawyerly instinct, I think, had a lot to do with why they're not willing to put up with, you know, positions that they pride themselves on actually being above politics, right? That is their belief, and we in the professoriate are often pushing back on that. On the other hand, you know, it's part of our American culture. It's part of our American democratic religion that we believe that all citizens are subject to the same law. And as a general principle, with a little Congress hiccup, these cases reaffirm that, you know, and I think that's a testament to the power of that ideal. They knew that if they gave him a pass on, which was a total pass, which he kept asking for, that the court would itself be the subject to enormous pushback and potentially give rise to movements that are already afoot to pack the court, to redesign the court, which Congress can. People don't remember this, but they can. Not a good idea, in my opinion, but they can. So, you know, I do think that is the very much the good news of this term, even if not all the decisions came down in the way that I would have liked.
I cannot imagine a better note to end on than that one, because I think it sums up these decisions, what they mean, and frankly, the dynamics of this Supreme Court term quite nicely. So thanks to all of the folks who submitted questions and all those who watched this. Thanks to our Georgetown Law colleagues for setting this up. And thanks, Vic, for doing this with me. This was fun.
Thanks, Josh.
Take care, everyone.